Good afternoon, but also good morning and good evening to everyone. We are about to start our webinar. Again, we ask everyone to please keep your cameras turned off and your microphone turned off during the webinar, so we can guarantee the good audio for all the participants. As you have seen from the screen, you need to use the task bar that shows on the screen to turn off the camera and the microphone. And there you can also find the icon for the chat function. We will be taking questions from the audience through the chat after the speakers have made their comments, after we've had the discussion in the panel. Feel free to also introduce yourselves in the chat, listing your name, institution, and country. And welcome to this fifth webinar of the Global Judicial Integrity Network. I'm Roberta Solis, the Judicial Integrity Team Leader at UNODC's Global Program for the Implementation of the Doha Declaration, which acts as the Secretariat of the Global Judicial Integrity Network, a platform of judges and for judges to provide support in strengthening judicial integrity worldwide. It is our pleasure to welcome you in this fifth webinar of the series of webinars organized by the network on the priority topics identified by its participants and that constitute new challenges for judges and jurisdictions across regions. With this initiative, we aim to continue to broaden the opportunities within the network for networking and knowledge exchange, in particular during this period in which in-person sessions cannot be organized. Before I introduce our speakers of today, again, we remind everyone to turn off your camera and turn off your microphone so we have a good audio for everyone. And now I would like to give the floor to the coordinator of the Global Program for the Implementation of the Doha Declaration, Mr. Marco Teixeira, who would also like to greet the audience of our webinar. Marco, you have the floor.
Thank you, Roberta, and it's my pleasure to greet you all to this fifth webinar of the Global Judicial Integrity Network. As it happens in previous webinar, I was looking through the list of the participants. We have participants from all over the globe, and this reveals the commitment, your commitment to the Global Judicial Integrity Network, and also to strengthen the judicial integrity. And once again, thank you for sharing your time with us. To begin with, I would like to stress the relevance of the topic of the webinar that brings into discussion elements that further enrich the network and also bring added value to the participants and allow judges to share and learn from other judges on priority topics and emerging topics of judicial integrity as reflected in the theme of the webinar that we'll have organizing and we are organizing today, financial disclosure systems for judges. Secondly, I would like to highlight that this series of webinars serves the purpose of the Global Judicial Integrity Network to provide judges with additional resources, examples, and good practices to encourage judicial transparency and judicial independence in the exercise of justice. Thirdly, I would not like to miss the opportunity to express our deepest concerns for the security and physical safety risks that judges are currently facing in different parts of the world. On this occasion, I'm referring to the regrettable assassinations of Judges Villegas in Mexico and Judges Meireles Duarte in Paraguay. So on behalf of UNODC and the Doha Global Program, I would like to express our sincere condolences for the death of those judges who until the end served their lives and dedicated their lives to serve judicial duties. Finally, and I would like to thank you again for showing your commitment and support to our initiative by attending this specialized series of webinars. And I hope and we hope this webinar will be useful for your functions, for your professional careers. And a special gratitude to our speakers today to make themselves available to share their expertise and also their knowledge. With that said, I think we have all the ingredients to continue to promote judicial independence and judicial transparency in many judiciaries all over the world. So thank you very much, and I hope you enjoy our webinar of today.
Thank you very much, Marco, as usual, for your support. So today in our webinar, we'll explore the topic of financial disclosure systems for judges. In the past, the suggestion to introduce such systems for judges was viewed with some skepticism by many in judiciaries as an effective method of strengthening judicial integrity and preventing corruption. Nowadays, this issue is increasingly gaining prominence again in many jurisdictions in the interest to uphold judicial integrity, transparency, and to identify or help identify potential conflicts of interest. This topic is of great relevance and intricacy, and therefore it is a pleasure to present the excellent members of the panel of experts we have today, who with their extensive experience and knowledge will guide us through this topic. Our panel today is composed of Chief Justice Đuro Sessa from the Judiciary of Croatia, who is also a member of the Advisory Board of the Global Judicial Integrity Network, former President of the Consultative Council of European Judges, and a member of the International Association of Judges. Former Judge Aneta Arnoldowska, Director of the Academy for Judges and Prosecutors for the Republic of North Macedonia, and Senior Anti-Corruption Expert at the Regional Anti-Corruption Initiative in Southeast Europe, and Justice Madame Lokur, Judge of the Supreme Court of Fiji, and former Judge of the Supreme Court of India. Dear panelists, thank you very much for being with us today. Today's webinar system will be a little different from the previous ones in English that we have organized. And in this case, we'll start the discussion by asking a specific question to each of the panelists, then ask another question to all three of them to encourage the discussion. And finally, we'll open the debate to the public through the webinar chat function. Thank you very much in advance to all for following the rules of participation of this webinar. Please keep your microphone silent and your cameras off during the webinar to guarantee the quality of the audio. For now, the first round of questions, we're going to start with Chief Justice Đuro Sessa. Justice Sessa, in different jurisdictions in Europe, the systems for the declaration of assets of judges have been implemented. Could you please tell us more about this topic from an European perspective?
Hello, everybody. Welcome again, and thank you for the opportunity to be part of this webinar and a very interesting and let's be fair, controversial topic among the judges in Europe. At least. Answering to your question, I would like to say that there is no unique system in regard to declaration of assets in Europe. Contrary to the general opinion, there are no much reliable sources which would provide comparative analysis about declaration of assets for judges. But from different sources, especially from the answers for the opinion number 21 of the CCJA, there are four main questions which should be addressed. First is which countries have their rules prescribe obligation to declare assets? Is access to those data free to public or only upon the lawful request? What is the ultimate reason to collect and control declaration of assets? And who or which body will be in charge to collect and administer declaration of assets? One of the reliable sources on European level is GRECO report on the fourth evaluation round on prevention of corruption among judges, and CCJ opinion number 21 on prevention of corruption among judges, and most important, preparatory work which was done to prepare such questionnaire. As I said, in Europe there is no unique situation, though, so there are countries which do not have obligation for judges to declare assets. Countries among those are Austria, Belgium, Cyprus, England and Wales, France, Malta, Portugal, Swiss Federation, Iceland and Luxembourg, Denmark, Netherlands, Spain, Germany, Sweden, and Israel. Among countries which access to data in declaration of assets are free to public are Bulgaria, Norway, but only for investments in shares above to 2,000 euros, Slovak Republic, Poland, Estonia, Montenegro, Latvia, Georgia, Croatia, North Macedonia, and Azerbaijan. As you can conclude, common denominator is that countries of so-called old democracies do not have obligation of judges to declare their assets. And in the states of so-called new democracies, this obligation exists in various forms. Second common denominator would, as it is found from the CCJ opinion, is the level of trust which general public and society as a whole shows towards judges and justice system. In most of the texts devoted to this topic, one will find rare reserve to the idea of declaration of assets, even though I must mention Greco is not consistent in their recommendations in a way that to some countries they recommend implementation or improving the asset declaration, and for some states even they do not have declaration of assets, and the recommendation in this direction is not existing. To mention again CCJ opinion 21, in the conclusions it was stated, a robust system for declaration of assets can contribute to the identification of subsequent avoidance of conflict of interest if relevant steps are taken, and thereby lead towards more transparency inside judiciary and contribute to fostering of the climate of judicial integrity. From this state, it is obvious that CCJ is of the opinion that only legitimate purpose for declaration of assets in broader sense of this term is preventing conflict of interest and improving transparency of the judiciary. So that will be for the moment, and of course I have some other remarks, but I will save them for the later discussion. Thank you.
Thank you very much, Justice Sessa. But maybe a follow-up question to your points now. We know that there is also some skepticism about financial disclosure systems, for example, as to whether they may be intrusive on the privacy of judges or if they have actually proved to be effective in identifying illicit enrichment or preventing conflicts of interest. Could you please share with us your opinion about these affirmations?
As I said, in my personal view, I share the opinion of CCGA. The other purpose of asset declaration is to find out illicit enrichment of judges or prevention of corruption. But in my opinion, it is also very important to note that for those purposes, there are other state organs which can find out such kind of enrichment or corruption among judges, and that is not for the declaration of assets purpose. So, especially because I think it should be undoubtful that judicial body should be the one which would collect and govern all the proceedings regarding the declaration of assets. And those bodies are not usually equipped so good as a taxation office or other prosecutor's office or some other IRS to control the assets. So I think that if we will keep it only to see is there a conflict of interest, should be judge recused, excused from the case, that purpose is fine to be served. But for other reasons, which are mostly used and in the countries, especially of the new democracies, that is not the case. And what is an even bigger problem, I don't think that they contribute to the integrity of judges, because the data there is falsely shown, and especially and sometimes mala fide used, especially through the media or the party. So I think that they do not serve the purpose which they should idea is behind it.
Thank you very much for these very insightful first comments. We'll pass now to Judge Aneta Arnoldowska. Judge Aneta, in your role as the Senior Legal Advisor to the Regional Anti-Corruption Initiative, you have facilitated the process of completing and negotiating the International Treaty on Exchange of Data for verification of asset declarations as a mechanism for financial reporting by judges. So maybe two questions for you. What is the importance of the treaty as a legal instrument, and what would be its real impact on the international exchange of data, improvements to regional cooperation, and strengthening of national verification systems? And also, what are the main challenges and dilemmas in the financial disclosure for judges in the SEE region? And where do you see the room for improvements taking into account the specificities of the judicial function?
Thank you very much. Thank you for inviting me this webinar on this important topic. So, Regional Anti-Corruption Initiative as a regional intergovernmental regional body facilitate the developing and process of signing ceremony for the international treaty. But unfortunately, due to the COVID pandemic, the signing ceremony was postponed. And in the meanwhile, RAI is working on promoting and inviting the states to sign and accede the treaty. The treaty provides for various of mechanisms which will facilitate the exchange of data among the integrity bodies from the various countries in the region regarding the asset disclosure data in a civil and administrative matter. So it provides for various types of exchange, then limits and deadlines for answering the requests, also limitation of the reasons for declining the request, guarantees for the confidentiality of the data exchanged, the possibilities for disclosure of information, and what is very important, it provides for the states parties to conclude among them bilateral agreements to further facilitate certain technical issues or issues regarding the language, possibilities for open sources, using open sources with bilingual, for example, surfaces, automatic exchange of data, and so on. It will further facilitate the exchange of office because it provides for establishing focal points, national focal points that will reduce the time-consuming procedure involving multiple governmental offices. Also will lead to developing monitoring and evaluation methodology on implementation and involving the civil society in the monitoring of the implementation. Of course, all this international exchange will further strengthen the national disclosure systems. From the other side, because it will detect the problems and the obstacles in interchange of data among different authorities in the country. Also will lead to developing databases, registers, cross-check of data regarding asset disclosure, and will lead to more concentrated and streamlined diagnosis of the problematic areas with higher corruption risks related to the asset disclosure, and especially related to the different categories of public officials, specifically for judges. This is about the role of the Regional Anti-Corruption Initiative. Your question about the problems and possible improvements of the systems in the southeastern Europe. I will also try to be brief, even though we have a lot of documents here. I can say several remarks to conclude that in the last decade, the judicial bodies in the southeastern Europe They didn't pay a lot of attention on the corruption behavior and monitoring and corruption monitoring and of corruption and measurement practices. But they dealt with questions of promoting independence, developing ethical codex, and there were no developed anti-corruption, dedicated sectoral anti-corruption policies in the judiciary. So the focus was more on repression rather than on prevention. Regardless who will lead the process of in-depth verification of the asset declaration, because there's no so clear international standard that will give the authority only to the judiciary to lead this process, no matter who is leading the process, there needs to be consolidated approach and to develop this robust system of asset declaration as a part of the corruption risk management, anti-corruption policies in the judiciary, but develop in close coordination with the anti-corruption bodies. So rooms for improvement are on the...
So I think we're having a connection issue with Judge Aneta. She will be back soon. Thank you so much for these very interesting points, Judge Aneta. And we'll certainly continue the conversation once the glitches are fixed. But then we'll pass now to the third speaker of today to close this first round of questions for the panel. Dear Justice Madame Locour, thank you for being with us. In India, the issue of judges' asset declarations has been gaining increasing prominence to the extent that the former Chief Justice and several Supreme Court judges, including yourself, declared their assets publicly. Could you please tell us more about the experience of the judiciary of India in this regard? And to whom do Indian judges submit such disclosures? Whether and under what conditions information contained in the disclosures is made available to litigants, lawyers, and other relevant stakeholders. Thank you. The floor is yours.
Thank you, Roberta, and thanks for the invitation. Just a brief background. In India, we have, for administrative convenience, a large number of districts. So there are more than 700 districts in India. And the trial courts are located in the districts. And a group of districts, it could be 10 or 15, would make up one state. In some other area, as many as 70 districts would make up one state. And so we have about 29 states in the country. So you have at the bottom of the ladder, so to speak, about 700 plus districts, and above that you have states, and then of course you have the government of India. Now, each state has a high court, which is a constitutional court.
Justice Locour is reconnecting.
Yes.
Yes, you're back.
Okay, sorry for the disruption.
No, okay. It's okay. We're all having some issues with the internet today. Don't worry. Please go ahead.
Yeah. So each district has its own district courts, which are the trial courts, and each state has its own high court. And at the top of the ladder, you have the Supreme Court. Now, for every state, there are rules and regulations for declaration of assets by the judges in the districts. So across the country, we have something like 19,000 judges. So there is no uniformity because each state has its own rules. But by and large, the rules are to the effect that every judge in the district has to give a declaration of his assets at least once a year. In some states, it would be twice a year. And that declaration of assets and acquisitions or anything that is being disposed of by the judge is to be intimated to the High Court in a sealed cover. So it is kept with the High Court, and if necessary, the High Court can always have a look at it to find out if there's any unusual financial activity by a judge in the district. In the High Court and in the Supreme Court, the procedure is somewhat different. In 1997, all the High Courts and the Supreme Court in the country agreed upon a restatement of values of judicial life. And this was reiterated much later again in 2008 or 2009. So under this restatement of values, every judge of the High Court, and there are about 1,000 judges, and every judge of the Supreme Court, there are 35 judges, all of them have to declare their assets in a sealed cover to the Chief Justice. So in the High Court, it will be to the Chief Justice of the High Court, and in the Supreme Court, it will be to the Chief Justice of the Supreme Court. In Delhi High Court, when I was there in 2007, 2008, we decided in a full court meeting that in addition to giving the information to the Chief Justice in a sealed cover, we have no objection. There was a debate about this, of course. We have no objection if it is put up on the website of the High Court. So Delhi High Court really is the only High Court, as far as I know, where the declaration of assets made by the High Court judges is on the website. In the Supreme Court, some judges have declared their assets on the website. As of now, out of 34 judges, 6 of them have declared it on the website, but the others have given it to the Chief Justice of India in a sealed cover. And that can be opened by the Chief Justice of the High Court or the Chief Justice of India, as the case may be, if it becomes necessary. So this is really the broad scheme. In the district courts, every year or every 2 years, in the High Courts and the Supreme Court, it is kept in a sealed cover to be opened as and when required, if at all. Yeah, that's the procedure that we are following. Thank you.
Thank you very much, Justice Lokur. I'm glad that your audio problem was a quick one. But maybe we have now back Judge Aneta. Aneta, would you like to pick up from where you left before we go into the second round of questions?
Yes, thank you. Sorry, I don't know what happened with the techniques. Okay, but I stressed, I mentioned the possibilities for improvements in the judiciary, but as well on the side of the anti-corruption agencies. For the anti-corruption agencies, when they are leading with the verification of the asset declarations for judges, it's very important for them to be independent and to follow the principles of judicial independence and internationally recognized judicial guarantees, and with a focus on the methodology for in-depth check of the asset declaration. It needs to be a methodology based on qualitative indicators that will not create in the public perception that the selection of particular judges for verification is selective. It can, in a long track, undermine the trust of the public in the judiciary when the judges are presented as all corruptive. So it's very important to have developed methodology, of course, cross-check and that develop databases with the other registers in the country. Thank you.
Thank you very much. And we'll have a chance to continue to explore your points and also the points made by Justice Lokur when we open the debate. But now we're going to move into the second round of questions. So as we have seen during this webinar in the first round, there is a real opportunity also to advance this discussion and exchange further experiences and learn from the jurisdictions that have introduced financial and similar disclosure systems for their judges. So now I'm going to invite all the panelists to share any ethical and or practical advice from their experiences and lessons learned for those considering a financial disclosure system in their jurisdictions, including if their views on how judges' asset declarations can promote transparency and prevent judicial corruption. So maybe with this second round of questions, we will follow the same order of the speakers and start with Justice Duro Sessa.
Thank you. It is not easy to respond to that issue globally. I can only say what is the situation in Croatia. So we have the obligation to give our declaration of assets at the beginning of our when becoming a judge, and then every year it has to be amended or to give up what is new in the assets regarding the assets which are collected. Of course, if there is such kind of obligation, then judges should obey. That's no doubt about that. So if that could be my advice, not to obey such kind of rules, because judges are the first who should obey any rules which are imposed on them as the judges. The second issue is, and that is the experience of my country, that access to the declaration of assets is mostly, or I would say always, misused, because as Aneta said, it is always the same judges who have this scrutiny of the public. These data are presented particularly. I would dare to say intentionally to confuse the public, general public, and to put the judge in a position to give another explanations and then so on. For example, we have a judge at the Supreme Court who is owner of the island. It is a small island. It is not island he's owning. It is only the lot of land which covers that small island, not bigger than 2 rooms. And always when they say how judges are rich, they put up his name and that he's owning the island, even though that island is in his family for 400 years. So this is how these data are used not to raise the integrity of judges, but completely opposite. So I would say that having that in mind, that public access to declarations sometimes doesn't serve the purpose it is created for. And so if there are that kind of declarations, I think it would be possible to access the data, but only if you have a lawful reason to do so. Of course, the media are among the circle of persons who should have that access, but it would be mostly created for the parties before the judge. So I'm rather conservative in this issue, and sorry, I can't help myself. Thank you.
Thank you, Justice Sessa, and that's the purpose also of this debate, to bring the different views on the topic. So maybe through the Global Judicial Integrity Network, we can provide jurisdictions everywhere some guidance on the topic as they also navigate these issues. Judge Aneta, what would be your take in this part of the questions?
Yes, thank you. So as Judge Sessa mentioned, there are systems without asset declarations, judiciaries without the asset declarations, and still they enjoy very high level of trust in the public. So that means that the asset declaration system is not the sole preventive mechanism, because all these developed countries, developed democracies, have very strong internal and external control mechanisms. Then the role of the civil society, independent civil society, I will mention, also free media, and lot of independence and transparency of the judicial self-government bodies. On the other side, there are countries from the region where I come from, and I will not speak specifically from the country because now I'm in the Regional Anti-Corruption Initiative. But what is the problem in the region? That allegations of corruption are not investigated properly. Allegation about the corruption in the judiciary. And usually during the election campaign, the politicians misuse these allegations for corruption to voice for general re-election of judges, also threatening judges that all asset declarations of each judge will be checked in depth. Then voicing for vetting procedures, lustration judges, and actually, in my opinion, judges are misused as collateral damage of the electoral campaigns by the politicians. So if there is allegations for corruption, all these allegations need to be investigated individually, and especially because it's about financial property of the judges. Parallel financial investigations need to be conducted and possible confiscation. Also, it's not, there is no ban that the judges can be rich. So that doesn't mean that judges need to be poor. But of course, judges are public officials with life mandate, and they need to put the interest of the judicial office above their personal interest. It's a definition, so I will repeat it, and to properly manage the financial interest. So it's very important just to avoid these draconic measures voicing by the politicians, to have this robust asset declaration system that will be implemented on non-selective way. That's for me very important. Independence and non-selective approach in implementation of this system. Thank you.
Thank you very much. And those are certainly very important topics, especially the topic of the systems not being the only element within a framework to prevent or combat corruption, promote integrity, or to any other extent. But let's hear maybe first from Justice Lacour before we continue this very interesting debate.
Yeah, thank you, Roberta. We have not had much of a problem in India so far as asset declaration is concerned. And normally, litigants are not really concerned about the asset declaration. But there have been some complaints. It is not that there has been no complaint at all. There have been some complaints, particularly among the district judges. And I think I had mentioned that in the high courts, we have a vigilance section. So if there is an allegation of corruption, then it is addressed to the vigilance section, or it is brought to the notice of the vigilance section by the complainant. And if the vigilance section, conducts some kind of an inquiry to find out if there is any, prima facie evidence of corruption, then of course it is brought to the notice of the Chief Justice of the High Court, and disciplinary action is taken against the judge or the judicial officer. So there have been some cases. I do know that when I was the Chief Justice of one of the High Courts, an allegation was made, a pretty serious allegation was made against one of the judicial officers, and it was found to be correct. So the judicial officer was placed under suspension, and later on an inquiry was held and he was dismissed. In the High Court level, there is not so much of corruption that has been made out. I can recall 2 instances in the last maybe about 20 years where allegations were made against 2 judges at different points of time of corruption. And we have a system of an in-house inquiry where judges and chief justices conduct a sort of an inquiry to find out if there is any substance in the allegations. And the report of the inquiry is then given to the Chief Justice of India for taking action. Now, there were two cases where there was evidence of corruption, and proceedings for impeachment were taken against these two judges. Both of them resigned. There was a third instance in which I was a member of the inquiry committee, of the in-house inquiry committee, and we found that there was evidence of corruption against a particular judge. And the three of us gave a report to the Chief Justice of India. But unfortunately, the Chief Justice of India did not take any action on the basis of the report, perhaps because of shortage of time, because the judge retired soon thereafter. So I think in the last 20 years, we've just had maybe these three instances, maybe a fourth that I can't recall immediately, but certainly not more than that. Now, so far as litigants are concerned, I have not come across litigants making frivolous complaints. Of course, some of them do, but each complaint is examined by the Vigilance Department of the High Court. And if there is some substance, disciplinary action is taken. Thank you.
Thank you very much, Justice Lokur. Indeed, very interesting points. I wanted to thank the three panelists for very interesting points raised in our discussion. I think that so far we've seen the various aspects that need to be considered by each jurisdiction as they embark on potentially developing asset declaration systems for judges, or if they embark on using existing frameworks also for the judiciary. I think there are very interesting points raised about who should have access to the declarations or not, how to verify the declarations. A very interesting point from Judge Anita is that there is no ban on judges having assets and income. And I think the very important idea that these systems are not something that would operate in a vacuum or as standalone systems. They need to be, when and if adopted within a whole framework for the judiciary and the overall anti-corruption, anti-conflict of interest, anti-illicit enrichment frameworks. So very interesting points already raised. We'll be opening now the floor for the questions from the audience. We already have quite a number of questions in the chat. We'll try to address all of them as much as possible. But in some cases, we might, in the interest of time, also combine some questions. And of course, this will not be the last time we debate this issue in the Global Judicial Integrity Network. So in case your question is not answered either in part or in total, please don't feel discouraged to continue this conversation with us and with the other participants of the network. So to start, we have two questions here that I'll maybe try to combine because they both relate to investigating when issues arise, how to investigate. So one of the question is on if there is an inquiry about whether judges pay taxes on their assets. And the other one is that corporativism avoids in some jurisdictions the possibility to investigate potential cases. And so the participant would like to know from the speakers if they would have any suggestions in case like that, how to guarantee that claims against judges are investigated. And we'll open the question to the three speakers. So maybe if one of you would already like to start.
Okay, Roberta, may I answer?
Yes, please go ahead.
Yeah. Well, as far as taxes are concerned, yes, the judges have to pay taxes. they're not exempt from taxes. So I think that's you know I think that's fairly obvious so far as India is concerned. The income tax returns of the judges are scrutinized by the income tax department. So if a judge for some reason gives incorrect returns, of course he will be taxed under the law and penalty taken, whatever it is. I have not come across any situation where a corporate has declined to participate in an inquiry against a judge. I have not come across any such situation at all. And it would be a little surprising if the judge himself, who is under investigation, tries to block it. Because then the inquiry might take an adverse view of his conduct in this regard.
Justice Sessa, Judge Anita, would either of you would like to take on this question? Otherwise, we'll move to the other ones.
Yes, if I can just add that I think there are two levels of investigation, and it is up. One is the taxation evasion investigation, which are done with the taxation offices, and that's one part, as any other citizen. And regarding, let's say, more serious investigations, if there is some criminal behavior behind the assets and which judge or his family possess, then it is up to lift the immunity and to start criminal proceedings. But so those who are initiating those proceedings have the bodies which they can look upon and see how those investigations are governed in a lawful way. So it's not up to judges to make any obstacles to such kind of investigations, but it is usually from declaration of assets you cannot find much. It is only if the judges are hiding some kind of properties, which is also a case in some countries, but in mostly judges are not so stupid to hide the property. They will declare everything they have, because it is the easiest ways to see that they are hiding something. So I think that is the one part, to declare everything, and investigation is something completely different. And not always those bodies which collect this data are the best one to make an investigation of are those declarations proper.
Thank you, and maybe since we are having some issues with the connection, could I suggest that we all just use the microphones and no video? Maybe that will help us with the difficulties. But Judge Anita, you would like to also answer this question?
Yes, also judges in North Macedonia, they are subjected to taxation. There was a very interesting example in the past. It was around 10 years ago, when a judge, of course, submitted us declarations to the Anti-Corruption Committee, and then there was suspicion on the side of the committee, of course, based on the media reports. They're always faster than all kind of authorities in the country. And there was allegation that all assets were not declared properly, and then she was taxed. The declaration was submitted to the State Revenue Office, and the judge was taxated with 70% of the non-declared property. So it was a kind. We don't have this provision because after that we introduced the Criminal Act on illegal enrichment. But so far, I will agree with my colleagues that the sanctions, we don't see enforcement of the sanctions in this area. So when looking at the comparative review in the states in the region, in our region, you may see administrative sanctions for violation of asset disclosure, but mainly failure to submit the declaration in the proper deadline and so on. But we don't have a case on illegal enrichment prosecuted and adjudicated towards a judge. And all disciplinary sanctions are mainly reprimands. Thank you.
Thank you very much, Judge Anita. And I think that the three of you have, at various points in the conversation, touched upon the topic of verifying the declarations, which is also a very important topic because in a lot of jurisdictions, a lot of data is collected through these declarations, but there isn't much work on verifying the data to potentially identify any suspicious activities. So we have some questions from the audience that touch upon also this topic, which is how to verify the authenticity of the content of declarations. Whether verifications should be done at a regular basis, if this should be a routine exercise, and how to monitor specific expenses in case the judges, for example, are granted corporate credit cards, for example, in their jurisdiction. So maybe if the three of you or whoever would like to address this could address more the topic of how to verify, should this be a routine or not, how to verify specific expenditures. So I open to the panel this topic.
Would you like me to take that, Roberta?
Yes, please go ahead.
Okay. You see, like I had mentioned in my opening remarks, that so far as the district judges are concerned, they have to give their property returns, so to speak, every year or every 2 years in some states. So if there is a discrepancy, if 1 year, certain assets are declared and suddenly there's a big jump the next year, the vigilance department would, of course, question the judge, whether it's in terms of acquisitions or, disposing of property or disposing of assets. So this monitoring goes on annually or once in 2 years, so far as the district judges are concerned. So far as the constitutional courts are concerned, that is the High Court and the Supreme Court, there is no monitoring on an annual basis. It is left to the judge to inform the Chief Justice if there is any acquisition by him. And if there is a complaint, of course, then the Chief Justice will, inquire into it. So really, in that sense, it's a matter of trust, where the constitutional judges are trusted to give correct information to the Chief Justice. Of course, if complaints are received and there does appear to be some substance in the complaint, they are dealt with, they're looked into, and like I said, we've also had in-house inquiries and found some judges guilty. So there is this, sort of a checks and balances. There is, of course, no surveillance in the sense that, does a judge have a corporate credit card, or, is he or she doing something which should not be done? There's no surveillance in that sense. So there's a lot of trust that is involved. And if there is a breach of trust, of course, action is taken in accordance with the procedure of the High Court and the rules that have been framed. Thank you.
Thank you, Justice Lacour. Thank you very much. Judge Anita, Justice Sessa, would you like to?
Yes, I would like just to add something, and that is that regarding the corporate cards, I don't think much judges are there who can enjoy that benefit. But if there are, then there are rules probably which are regulating this area, how much can be spent, when, on what occasions. So that is the way how to control that. It's up to the system, especially I think it's within the, at least with the Ministry of Finance or the Ministry of Justice. One issue is missed and hasn't been mentioned here, and that is that when you speak about declaration of assets of judges, we are having one eye on the other branches of power, forgetting in that comparison that the judges are for a very long time judges, and that they have a steady occupation with a steady income, and that this declaration of assets as obligation came just lately, so that when the judges were not in a position to save all the documents and everything, and so sometimes it's very difficult to report properly what is the source of the assets, and so sometimes it brings a confusion. And regarding the length of the judicial post, and that is usually for life, at least to the age of retirement, I think that this term of reporting the changes in declaration should be longer than 1 year, even though in many countries, including Croatia, it's every year you have to declare all the changes to the assets which are reported. So I think these issues are not taken care of when you speak about this obligation for judges. That is that they are appointed for life.
Also, I will add that first and utmost question is having a clear and comprehensive legal framework related to the asset declaration system, about the time limits, about the scope of the declaration. So each of these items, it will be constructive to develop guidelines accompanied with clear examples on each of the notions mentioned in the law related to the asset declaration. So it's very important to have clear provisions about the mandate of the agencies for in-depth verification and when to verify. Let's be realistic. For example, in North Macedonia, it's not a very large country. We have around 600 judges and 200 prosecutors maybe. It's not realistic for the Anti-Corruption Committee to in-depth verify and scrutinize all these asset declarations. So there's need to be a comprehensive methodology how this and in which timeline this declaration will be checked, of course taking into account the higher corruption risk categories of judges, for example, judges dealing with high-profile corruption cases, commercial judges, or new recruited judges. Still, I will mention one additional question, because Regional Anti-Corruption Initiative is working on the has been working on the developing the methodology of corruption proofing of legislation. One of the deficiencies in our laws in the judiciary in the region is lack of corruption proofing. So detecting the corruption risks in the provisions of the law that can provoke corruption. So including the law on corruption and asset declaration, this need to be checked in advance for corruption proofing. But anyway, developing guidelines, tailored training will help judges to interpret some of the notions that are maybe problematic related to what to declare and which are the declarants. Thank you.
Thank you, Judge Annette and Judge Sessa. I think those are very interesting points, and usually in the jurisdictions, the system for the mandatory disclosure of assets and asset disclosure verification usually is attached to the regular procedure for income taxes. So it's usually attached to the procedure that is for all citizens to declare their assets and income related to income taxes and other established IRS procedures. So it's interesting to see how judiciaries potentially adapt these usual systems to the reality of the judiciaries. And I think that the discussion here is very interesting in raising the specificities of the judiciary that should be taken into consideration when doing that. So we have quite a number of questions in the chat. We have one here that I think it's a topic that we haven't touched upon yet, which is what would happen if financial irregularities prior to the appointment of the person as the judge was found out after the appointment. If there are any provisions in the legislations that you are aware of or in your jurisdictions. So how would a case like this be addressed, and if it would be addressed?
Okay, can I take that, Roberta?
Yes, please go ahead.
Yeah, you know, we had one instance of one of the judges in the High Court. There was some allegation against him of misuse of funds. He had been appointed as a receiver in some with respect to some property, and he had siphoned off some funds. This was not known at the time of his appointment as a judge, and he was appointed to a high court, to a constitutional court. But later, I think within a year or within 2 years of his appointment, it came to be known that there was some problem. And he had not declared his assets with regard to the account that he had opened up as a receiver. So when investigations were conducted, it was found that he had not given a correct or a full declaration, that he had misused funds, and proceedings were taken against him for impeachment. And before the final verdict could be delivered, the judge resigned. So this is perhaps the only instance that I know where a person who was before his appointment had done something illegal. To an extent, it continued even after the appointment because of non-disclosure. But the judge resigned before he could be impeached. I am not aware of any other case like this in India. Thank you.
Thank you. That's very interesting, and it also raises the question of linked to judicial disciplinary proceedings, which is another topic that it's something that we'll also be focusing on under the Global Judicial Integrity Network. And we often hear about cases that the disciplinary proceeding doesn't go until the end, until the investigations are not finalized or the sanctioning is not finalized because of the retirement of judges. So maybe that's also a topic for us to continue our conversations in other webinars. Judge Anita, Justice Sessa, would you like to add something to this point, or should I move on to the next question?
If I might say, it depends. What are the obligations for the candidate judges? So are they in obligation to disclose their assets before the appointment or not? And then, of course, there is always a possibility to remove the elected judge from the bench if he or she give the false data, which were crucial for the appointment. So it is always, I think, the balance between the obligations for the candidates and what can be done afterwards in a system of the appointment and disciplinary responsibility of appointed judges.
Yes, you mentioned actually that the field of disciplinary measures definitely need to be subject of another webinar, because if we start with the disciplinary procedures, there are a lot of international guarantees developed by CCG, by Greco. So we didn't have such a case where the judge was dismissed, but I will here raise the problem that was also analyzed by the CCG in the opinion 21 mentioned by Judge Sessa about the discrepancy between the real and perceived corruption among judges. So it was in the past I made analysis of the disciplinary procedure in North Macedonia. It was maybe 2-3 years ago that for 10 years, in 10 years, there were 44 procedures for dismissal of judges. And out of them, only 2 judges were criminally investigated and prosecuted for receiving bribe. So the discrepancy is very, very large, and it also undermines the public trust in the judicial. Thank you.
Thank you very much. And since we have you as a speaker, Judge Aneta, there is a question here that is specifically to you. It's a 2-part question. I'll read both. In the regional initiative, are these anti-corruption bodies, the ones which exchange data, are they independent from the government? And what are the reasons to open the sealed envelopes? What are the reasons for the disclosure of the assets?
Thank you. So anti-corruption agencies in the region of the RAI regional initiative, regional anti-corruption initiative has 9 member states. All they have specific anti-corruption agencies, and they are independent institutions. I can say that from the comparative analysis from the Greco, as well RAI thorough analysis when working on developing the methodology and the IT tools for corruption risk assessment and corruption proofing of methodology with the main partners, the anti-corruption agencies. In my opinion, it is very important for the in-depth verification of assets, when I mentioned the independence of these agencies, the procedure for appointment of the members of the anti-corruption agency, of course, the powers they are provided according to the law for taking investigative powers, and of course to act in the public without political interference. Political interference on the anti-corruption agencies can be in a selective approach of in-depth verification of the asset declaration. But most of the time, these disclosures of the public disclosure of the asset declarations of judges are upon media reports. So, for example, in our country, in North Macedonia, it happens when a judge has to deal with very important high-level corruption cases, of course, always involving politicians. In a case of promotion to the higher position, of course, new elected judges but believe me, in the meanwhile, because the asset declarations in North Macedonia, they are published online, there is no very huge interest for attending this and reading these asset declarations. So only in a case of a media attractive case. Thank you.
Thank you so much. Thank you so much. And I think that you also raised some points that have been discussed for quite some time by the anti-corruption agencies in the executive branch, and also under the framework of the UN Convention Against Corruption. I think a lot of these discussions on asset declarations, access to information, even proactive transparency of asset declarations have been ongoing for quite some time as well for the executive branch, for the legislative branch. under the framework of the Convention Against Corruption and other, of course, also instruments against corruption. So it's interesting to see how these discussions also apply and need to be adjusted to the context of the judiciary, especially because of judicial independence. So this is not used as a way to undermine that important principle. And I think this links to a question we have here in the chat, whether the public access to information should be prompted as a principle under the United Nations. I believe it already is under the UN Convention Against Corruption, the systems for the disclosure of assets and the verification of assets as a means to prevent corruption, to identify potential cases of conflicts of interest and illicit enrichment is already a principle there, and the convention also applies to the judiciary. So, Justice Sessa, we have here a specific question to you. So our participant would like to know if you believe that the access of the general public to the assets information of judges could place at risk the security of judges in some countries, especially for judges working in criminal cases.
Yeah, thank you. I think that it especially depends on the size of a country, and the smaller country it is, it's easier to, even the personal data are not fully accessible to the public. It is easy to find out, for example, where the judge is living, where he or she has assets, and so on. So I think that is a problem, especially with in this information age. And in my experience, I don't think that we should divide the judges between the criminal field of justice and the civil field of justice, and that all judges are exposed and there are risks for their security equally. Even in my country, the judges of the civil field there will be higher numbers of attacks on them than on criminal justices. Even they are more protected than civil judges. So it is a risk for security as well. So my bottom line is that those data should be available, but not on the internet.
Yeah, thank you. That's a very interesting point. Justice Lacour, would you like to also add to this question?
Yes, please.
Yes.
You know, we had discussed this in the Delhi High Court in 2009, you know, when the issue of declaration of assets came up. In terms of the restatement of values of judicial life, judges are expected to, the constitutional courts, they're expected to declare their assets in a sealed cover, in an envelope, to the Chief Justice of the High Court or the Chief Justice of India. Now, one of the issues that was raised by one of the judges was, is there any harm in disclosing it on the website in the Delhi High Court? Some judges were of the view that you know, placing the assets on the website is dangerous in terms of security. So there was a debate. We had a debate for about 2 days. You know, all the judges sat together and debated for about 2 days whether it should be placed on the website or not. And at the end of the 2-day discussion, it was decided that, well, there's no harm. If somebody wants to know what are the assets, you know, that person can always find out by hook or by crook. So there's really no harm in declaring the assets. This was in 2009, and it was placed on the website of the Delhi High Court. So between 2009 and today, 2020, 11 years, there has been no security risk to any judge of the Delhi High Court for the declaration of assets. So there is this fear, of course, there is this fear. And in the other high courts, they have not, placed the assets on the website. But if you come down to it, perhaps the fear is somewhat exaggerated. At least that is the experience that we've had in Delhi. Thank you.
Thank you. Thank you for that very interesting, specific experience of going through these discussions. Aneta, would you like to also comment on this point?
Okay, maybe I can recall some recommendations imposed by the Greco to particular countries to, for example, extend the publication of asset declarations related to the members of the family. It's also very complex issues. For example, as I remember, Poland got, but only consideration recommendation. That is not, of course, obligatory, but the authorities considered this issue and found that it was against the constitution of the country. So what in that case, if we have a clear case law of the European Court on Human Rights, for example, we refer to this case law in our international treaty for exchange of data, that the data contained in the asset declaration is public. It should be considered as open data, but I cannot remember another judgment. For example, in this case, no matter of this judgment, where the court found that there was no violation of Article 8 of the Convention because of publication of asset declaration, I think that always need to be this balance between the contradictory rights strived when assessing whether to prevail the public interest or private interest of the judges. But because the judges are public officials, of course, the level of privacy is a little bit lower in comparison to the other citizens. Also, the issue of, this is the issue of the danger of publication of the asset declaration for the criminal law judges. Because I was a criminal trial judge, I have never experienced such a threat because of publication of my asset declaration, as well all my other colleagues from North Macedonia. But I think that more complex is the question whether the publication of asset declarations gives a full picture about the real assets of a judge. So you can have public asset declaration, but if they are empty and if they are not checked properly, so the publicity of the asset declaration doesn't have any preventive or even repressive role. Thank you.
Thank you, Justice Lacour and Judge Aneta. This point is also pertinent because in some jurisdictions it's not the full asset declaration that is public, but in some cases it's just, for example, the amount of the salaries. So it's not the full picture of, for example, what the judges do with the salaries that they receive in terms of which assets they might be acquiring or selling, but only in terms of the salaries that they receive, because it's considered that that is public, those are public funds, so public funds should be transparent, the disbursement of them under the transparency of budget allocation. So that's an interesting also idea for some jurisdictions to consider in the debate. So maybe on the point of verification of assets, we have a question, some questions in the chat about how to verify the declaration. So methodologies that should be considered as a complete analysis of the assets of the judges to identify potential suspect activity, how to analyze that, if there are any good practices or even biggest challenges that any of you would like to discuss. So the question is open to the three panelists. If you would identify any good practices or even challenges or good practices in terms of methodologies to assess asset declarations.
Well, can I come in, Roberta?
Yes, please go ahead.
Yeah, I think, you have to proceed on the basis that the judge is honest, and that there is a correct declaration made by the judge. And later on, if some information does come to the notice of, the concerned authorities, an investigation can and should be carried out. So I had mentioned in my opening remarks that, we have a vigilance department, which consists of a large number of, officers. So if there is a complaint, that can be verified to find out whether the complaint is correct or not. If necessary, the assistance of the police or some other authorities can be taken. The income tax authorities, for example, the IRS. So the government machinery can be used by the vigilance department if it becomes necessary. So really, there is this check, that is available through the vigilance department. And I know that some of the high courts have pretty large vigilance departments because they're, working on this all the time. Because you keep getting complaints. Many of them are frivolous. Some of them are not. But anyway, the vigilance department has to look at each one of them. So that is perhaps the only method of, verification. But I think the starting point is that, you have to trust the judge as being an honest person and, go on the basis that the declaration given is correct. Thank you.
Thank you, Justice Lacour. Maybe as a final question, I will ask this question, but to the panelists, please feel free to also address other points because this might be a very specific question, although it seems to be a very interesting one and very modern challenge. So we had a couple of questions in the chat about how could a system for the verification of assets also take on the issue of disclosing or verifying the disclosure of crypto assets. So what would happen in the case of investments in cryptocurrencies, how to address that very modern issue?
I don't know the exact answer, but I will say that in-depth verification of the asset declaration, of course, need to reveal undermining corruption and undeclared asset. That's why it is important to have the digitalization of this system and interchangeable interoperation coordination among the authorities holding this information. Unfortunately, all these systems are very expensive. We know that they are very expensive softwares to have these centralized databases and exchange of information. And what can I stress that in our countries, these systems were introduced or maybe developed by foreign projects. It is very important to streamline the projects in line with the needs of the beneficiaries, because you cannot develop electronic system for digitalization of asset declarations if there are no absorption capacities of the beneficiaries. So it needs to be taken into account that all these projects we are developing for the asset declaration systems, for their modernization, need to build the capacities, internal capacities of the people, and regard the crypto. How did he say crypto? Values. Yes, crypto values. So I mentioned previously in my presentation, in my discussion, that what is important to have these developed skills and expertise for financial investigation. If you have traditional people employed in these agencies, they cannot reveal such kind of hiding of assets, and in this case, crypto values. So resources, capacities, and specialized knowledge on these issues is very on financial matter. Thank you.
Thank you so much, Judge Aneta. Justice Lacour, Justice Sessa, would you like to add to this point?
Sorry, go ahead. Sorry. Go ahead, Chief Justice.
I'm not very familiar with this cryptocurrency issue. I have to admit I do not understand it at all. But regarding the control, I think the first point is the public records which the state have. So that means land register, that means taxation, that means other assets which are registered. And so if there is some discrepancy in that, that could be a starting point for the investigation. If serious doubt is there that the judge is having more assets than declared, or lives in a lifestyle which doesn't compare with the assets he or she declares. So it is always a matter of how to find that first suspicion to go there, because having this regular checks is also something which I think should not be done without any reasonable doubt or justified reason.
Thank you, Justice Lacour.
Yeah, thank you, Roberta. I think it's a very interesting question. Of course, we haven't had any problem like this, but it is, I think, very interesting. And if one looks at the future to see how to tackle issues of corruption through modern technology, cryptocurrency, and so on, or transfer transactions. I think this is an area that should be given some serious thought. Frankly, I haven't given it a thought, and I don't think our judiciary has actually given it a thought. But were such a case to come up, we have experts in the government whose assistance would definitely be taken. But how does one prove corruption in a situation like this? Perhaps only an expert, can advise us. But I must say this is, a very interesting and futuristic kind of question, which does definitely require a lot of thought. Thank you.
Thank you. Thank you so much. Indeed, a very futuristic topic, but perhaps one topic that we'll soon have to continue to discuss and more in depth. Thank you to all of the participants. Special thanks to the speakers. We are a bit way over our time, but also we let the discussions continue a bit longer because of the technical difficulties. Before I conclude, I would like to ask if any of the three panelists would like to add any final remarks before we conclude this webinar.
No, but only to thank Roberta and you that you took this idea through to have this discussion, because this is the issue which we shall speak, I think, a lot about in the future.
Yes, I would join Chief Justice Sesa, and thank you, Roberta, for this very interesting discussion. On a very, very important topic, which I think concerns judges all across the world. Thank you very much, and of course, thanks to Judge Aneta as well for this wonderful discussion. Thank you.
Thank you, dear Roberta, and also thank you to the UNODC Judicial Integrity Group Network. We hope that we will continue our close cooperation with our organization towards detecting these problematic issues and developing measures for improvement the system. Thank you very much. Thank you all the team.
Thank you very much. My personal thanks to all of the panelists. This was indeed a very interesting discussion, and like I mentioned, I think it's going to be a continued discussion in the network. It is a topic that we have been working on since the launch of the Global Judicial Integrity Network. For example, at the launch event of the network, we had a breakout session on this topic, co-organized with the World Bank and the Judiciary of Argentina. And we're now having this webinar, and we've been having some other discussions as well. So I'm sure that this is a topic that will continue. Thanks to the panelists for their extremely interesting and invaluable experiences, insights, and good judicial practices on the topic of systems for asset declarations of judges. Certainly, this issue and this discussion was very timely, and this webinar, I hope, provided a good opportunity to advance this debate. Many thanks also to everyone who joined us today for this webinar. Thank you for being with us in this 5th webinar of the Global Judicial Integrity Network. Please stay tuned, because we'll continue to organize other sessions of our webinars. And don't forget to visit our website to learn more about the work that we're doing on this topic and many other topics of judicial integrity. I would like to let you know that the next webinar is going to take place on July 16. It will be on the subject of enhancing confidence in the judiciary. On this occasion, and in order to encourage multilingualism and promote regional partnerships and collaborations, the next webinar will be held in Portuguese. So we'll soon be sending the invitations for everyone to join our first webinar in Portuguese, for those that can follow the discussions in that language. But we will also continue with other sessions in English and also in other UN languages. So thank you again to everyone for a very interesting discussion. Many thanks to the speakers, for everyone who contributed in the chat and with their participation. And stay tuned for other activities of the Global Judicial Integrity Network. Thank you very much for joining our webinar. As a final note, we have also circulated a survey to judiciaries, to all of the participants of the network, to collect information about the measures that judiciaries are adopting during the pandemic, during the COVID-19 pandemic, and the impact of these measures. So if you haven't received the link to the survey, please get in touch with our team through our dedicated email account. And please feel free to disseminate the survey in your judiciaries and among your peers to help us collecting interesting and valuable information that is going to help us continue to provide in the network assistance to judiciaries everywhere to address challenges to judicial integrity. So thank you very much.
Thank you very much to all of you for participating and being part of this webinar. We look forward to your participation in the coming webinars of the Global Judicial Integrity Network. Thank you.